Hey everyone, welcome back to the channel. In today's video, we're diving into the wild story of a guy in court trying to fight a protection order violation against an actual lawyer. Here's the backstory. The lawyer originally filed the PO while representing a client in a case involving this man's mother. Things escalated when the lawyer sent a cease and desist letter, and the defendant fired back with a nasty, emotional response defending his mom. That heated exchange led the lawyer to file a protection order, and now we're here with the alleged violations. Buckle up, it's a long one, but totally worth it. Let's get into it.
We are here in the matter of Sarah Fazio versus Nevin Cooper Keel, case number 23-00563PH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court this afternoon for the evidentiary hearing regarding an alleged violation of the court's personal protective order that was filed on or about June 10th of 2024. At this time, I'd invite Mr. Hengeveld. Would you like to place your appearance on the record?
Yes, good afternoon, Your Honor. I'm Jeff Hengeveld on behalf of Sarah Fazio.
Thank you. And Mr. Cooper Keel, would you please state and spell your full name for the record?
My name's Nevin Cooper Keel, first name spelled Nevin, last name Cooper-Keel.
Thank you, sir. And Mr. Hengeveld, this is your hearing on the alleged violation, so you may proceed.
Thank you, Your Honor. I have one witness to call, and that is Ms. Fazio. Ms. Fazio, can you please tell the court who you are?
My name is Sarah Fazio. My last name is spelled Fazio. I am the petitioner in this matter.
Okay, and are you a licensed attorney?
Yes, I am. I've been a licensed attorney for 24 years.
All right, and how did you first come to know Mr. Cooper Keel?
I sent him a cease and desist letter on behalf of the client I think it was on June 23 of 2022.
Okay.
That was the first interaction I've ever had with him.
And in response to your cease and desist letter, what was Mr. Cooper Keel's reaction?
He sent me a series, several, I don't know if I have the exact count, of emails to my office email address that were a little unhinged and made little sense. I did respond to, I believe, the first one, if I recall correctly, instructing him not to contact my elderly client and to please direct future correspondence to me. He then proceeded to send me several threatening emails that he was going to sue me, he was going to sue my law firm. I ignored those to my best of my ability. And then he started up again in, I believe, January of 2022 or 23. I'm sorry. I started receiving a litany of additional emails that were more unhinged and more, that he was coming to my office and I was going to get something from him and that sort of thing. And that's when I initially filed for the PPO.
And under that PPO, the terms of the PPO, what is Mr. Cooper Keel prevented from doing as it relates to you in contact with you?
He is not to have any contact with me. He's not to reach out to me in any way. Not to send me things, come to my home, come to my office, appear within my site, that sort of thing.
Okay. And now we're here today on the motion to show cause for violation of the PPO, and I want to cover the factual basis for that motion. Were you represented by counsel in a lawsuit that Mr. Cooper Keel filed against you in Allegan County Circuit Court, that being case number 23-67017CZ?
What do you mean by relevance? They're literally going over the foundation of the original protection order violation. That makes it extremely relevant, especially since this hearing is to determine whether that PO was violated in the first place.
Objection. Relevant.
What do you mean relevance? They are covering the basis of the original PPO violation, so it's extremely relevant, especially since this is a show cause hearing for a PPO violation.
Response on the relevance objection, Mr. Hengeveld.
Yes, Your Honor, this violation, the factual basis for the violation relates to contact arising out of the lawsuit I just referenced. where I was counsel for her, Ms. Fazio, and I'm laying the factual foundation for why there is to be no contact directly with Ms. Fazio in that lawsuit.
Insofar you're laying it in that your argument's going to be, well, that contact should flow through you as the attorney.
Yes.
All right. Response, Mr. Cooper-Keel.
My response is that the Michigan Court Rules, Chapter 7, Section 2 for the appeals court says that until an attorney files an appearance in that case, they are not representing the client. So for that to be relevant, he would have to be representing her in that case, because I think what they're getting at is that I served a copy of a motion from an appeal where she was not represented, not this other case he's asking about. So I don't see the relevance of the other case.
Okay. And response on wrong case argument, Mr. Hangeveld.
Yes, Your Honor. I was always the attorney for Ms. Fazio in her capacity as it relates to the lawsuit out of which the appeal arises. There was a motion for reconsideration filed. Whether it's my strategy or not to respond either to claim for interlocutory appeal or to not respond to a motion for reconsideration because it's not required to be responded to or not allowed to be responded to under the court rules. All of that doesn't obviate or vitiate my appearance on behalf of Ms. Fazio, my representation of Ms. Fazio. If that were the case, then you could make contact directly with a party and when they were represented by counsel. Clearly that's not what the appearance rules require or provide for. In other words, I'm the attorney for Ms. Fazio. Mr. Cooper-Keel knows that, and whether or not we chose to file an appearance in the Court of Appeals for an interlocutory appeal or not is not relevant.
And he's absolutely right. Appeals are usually filed by someone who disagrees with or lost a previous court ruling. If an attorney was officially listed during the trial, it's assumed that same attorney will manage the appeal. So, if you send any court documents directly to a represented party instead of their attorney, that's considered unethical. And for someone representing themselves, it could count as a violation of a protection order.
Okay.
DPO.
Well, and I would tend to agree with your argument there, Mr. Hangeveld, and that typically when a person has, what I'm going to call as actual notice, that is, they know that an attorney represents another person, they are generally precluded from contacting that other person directly. And the forum, that is, whether it's the Court of Appeals or the District Court or the Allegan Circuit Court or the Kent Circuit Court, is not the controlling factor there. It's the representation itself. I'll overrule the objection and allow the response.
All right, so the question again, Ms. Fazio, was, were you represented by counsel in the lawsuit that Mr. Cooper-Keel filed against you in Allegan County?
Yes, I was. You were
Who was your counsel?
You were in Price Hunteville.
Okay. And as it relates to the claims against you in that lawsuit, what was the outcome?
I should say Plunkett County. I apologize.
Okay.
What was the outcome? The outcome of the underlying case in the state court was dismissed.
Okay. And then it was subsequently taken up in an interlocutory appeal?
That's my understanding, is that it was taken up in an interlocutory appeal. That's correct.
Okay. And what is your understanding of the outcome of that interlocutory appeal?
It was denied.
And after it was denied, and again, I'm going to show you momentarily your some exhibits, but after it was denied, the interlocutory appeal was denied, do you know whether Mr. Cooper-Keel filed anything further to address that denial?
Yeah, I believe he filed, and I can't remember what the document was called, but he filed a late document, or motion for reconsideration, I believe is what it was entitled, or something to that effect,
Okay.
With the Court of Appeals.
Your Honor, I can either put it up on the screen if you'll allow me to share my screen, or I can just reference it. These are just the exhibits to the PPO motion. What would Your Honor prefer?
Why don't you go ahead and display it on the screen?
All right. Ms. Fazio, can you see what I have displayed on my screen?
Yes, I can.
Okay. And what is that? what is this that's displayed on the screen?
The motion to show cause for violating valid personal or foreign protection order.
Okay.
It's the one that I filed in this case.
Okay. And what is Exhibit A to that motion? And I have it up on the screen.
It would be the motion to reconsider denial of appeal for lack of merit that Mr. Cooper Keel filed with the Court of Appeals.
And is there any particular part of the motion to reconsider that you consider to be significant or relevant to the PPO violation?
Well, I mean, initially I felt like it was a violation of the PPO because it was sent directly to me, as opposed to being sent to you as my counsel. You appeared on the Court of Appeals Register of Actions as my counsel from the moment there was a Court of Appeals action opened. Mr. Cooper Keel had to actually add me as a party on the My File case for the Court of Appeals, so that he could independently email this to me, as opposed to sending it just through the My File system, which would have automatically copied you and did copy you and all of their counsel of record at the time. So I felt like the initiation of contact was both a violation of the PPO, and if you look at the content of the motion itself, it's quite inflammatory and violent. I look forward to whatever Trump does to the judiciary at paragraph 6, and I hope it involves the public executions he's recently talked about, French Revolution.
I honestly don't know what's going through her mind. Those actually sound like completely valid legal arguments you'd bring up in an appeal. Unless, of course, she's not delusional, and instead, you just thought you found some clever loophole to keep. Harassing the person who already has a protection order against you.
I know of 3 little punks. I think the next one, paragraph 7, I know of 3 little punks. I don't know. That pretend they're trash lawyers breaking into my house lacks merit for them to explain. I eventually met the appellees. That's me, I guess. And of course, they are also pathetic people. The same people would be dumb enough to concoct such a scheme against me. Same dumb ones that get caught. Same dumb mentality of judiciary to pretend this appeal lacks merit. I mean, this is just sort of, calls the court pussies. I mean, it just sort of is kind of the similar tone as all the emails that I received from Mr. Cooper Keel.
Okay. And then you mentioned this already, but let's go to Exhibit B. What is Exhibit B, and what was the purpose of you including it?
Exhibit B is the Court of Appeals Register of Actions that shows that you are my counsel of record and have been. Yeah, and I point to page 9 of that, I guess 9 of the motion, which would include Exhibit B, indicating that I'm the attorney for both Ms. Fazio and her law firm, Price Underley. And then what is Exhibit C? This is the My File receipt that Mr. Cooper Keel, that shows that Mr. Cooper Keel added me as an individual for e-service, and I guess no one else. So he wasn't satisfied with the attorneys of record, so he made sure he added me so that I would receive it.
And finally, what is Exhibit D?
Exhibit D is the email I received on June 10 from My File indicating that I was added to that case so that I would, and then attaching a link to that, I guess, motion for reconsideration that was filed with the Court of Appeals.
And for the record, that's June 10th of 2024 at 11:50 p.m., correct?
Yeah, correct. Most of his emails come in late at night, early in the morning.
Since this contact on June 10th, 2024, has Mr. Cooper Keel attempted or had contact with you thereafter?
Yeah, he attempted again on December, let me look here. I think it was December 2nd. I received an email from My File that stated that was, well, it's from My File, but it stated that Devin Cooper Keel was attempting to add himself as a connection to my My File account, which, had I allowed it, would have granted him access to all of my cases, all of my filings, and all of the cases that are using My File. And it would have given him access to my payment source, my credit card that's on file for the filing fees on the pleadings. And then on December 5th, I received an email from Debbie Brewer, who's an office manager in the old building I used to be in in the trust building at 40 Pearl. indicating that Mr. Cooper Keel was attempting to send me a package to my attention at my old professional address. I had moved out of that building in 2020, but I just instructed her to return it to.
Court says no contact. They mean absolutely no contact or even an attempt to contact. Sending a hostile letter dressed up as a legitimate legal document still counts as an attempt to reach out, and that's exactly what you were ordered not to do.
Your Honor, I don't have any further questions at this time. Thank you.
Very well. Mr. Cooper Keel, do you have any questions for Ms. Fazio?
Yes. In Exhibit B, the Register of Action, I didn't see a date as to when the attorney Hangeveld was added as counsel. Is there any date on Exhibit B for when that list was produced?
That list was produced on June 11. I printed that off the day after I received the 11 something p.m. email from you. So it was June 11 that I printed it. I don't know on the Register of Actions if he was ever added. I think it just comes up from the state court, as every attorney that's of record in the state court.
Okay, so that was a Register of Actions from the state court, not the Court of Appeals.
No,
correct?
that was just, nope, that's wrong. That was a Register of Actions from the Court of Appeals.
Can your attorney put it back on the screen and show it to me? Because first time I've ever seen that.
DOA docket number at the top there on Exhibit B. That is the Court of Appeals Register of Actions from June 11 of 2024.
And when was the date that Mr. Hangeveld filed an appearance for you in that case?
I don't know.
What? I'm sorry, I didn't hear you.
I don't know.
And she did not know.
Okay. So you don't even know when you filed an appearance in this case?
I didn't file an appearance in this case. I'm a party, not a lawyer.
I mean your attorney, Jeffrey Hangeveld, you don't know when he filed an appearance in that Court of Appeals case.
That was my testimony.
Well, your PPO complaint says that he did file an appearance for you in that case, doesn't it?
Asked and answered, Your Honor.
I don't know what, I don't have it in front of me.
Hang on, let me rule on that objection, Ms. Fazio. Response on asked and answered, Mr. Cooper Keel.
I don't recall when it's been asked and answered. In fact, they claimed that he represented her, but
Yeah, he elicited testimony that he was the attorney. Are you asking something different then?
yes, I'm asking when did he file an appearance?
I already answered.
And she
You're
already,
referring to the appeal in this matter.
All right,
Is that-
yeah.
I don't want to put words in your mouth. You might
She doesn't
say
know.
that.
She said she doesn't know when.
Okay.
So I guess, yeah, that's, I don't object or, want to push against the objection. They're right. Asked and answered.
You may continue, Mr. Cooper Keel. The objection sustained.
You might as well get used to it because you're going to hear the judge sustain objections from the actual attorney throughout this entire video.
Isn't it true that in your PPO complaint, you claimed that he had filed an appearance in the Court of Appeals?
I'd have to see the complaint. I don't know. He appeared for me from the moment there was a Court of Appeals action.
For an attorney to appear for somebody, don't they have to file an appearance?
she asks for a legal conclusion.
All I know is that he appeared as counsel of record from the moment I saw the docket at the Court of Appeals.
How did you get the Register of Actions from the Court of Appeals?
It's available online.
Where at online?
I'd have to go look up the URL. I don't know.
Okay. I'm just wondering where that came from because I don't know how to get one for the Court of Appeals.
Is there a question?
How do you get the list? register of action?
Your Honor, she already testified. Objection asked and answered. She already testified. She does not know. She would have to look up the URL, which is not on Exhibit B.
Okay, and I did hear that asked and answered before, and she said she doesn't know as we sit here today, so you may move on to your next question, Mr. Cooper-Keel.
So how do we even know that register of actions came from the Court of Appeals?
Because I obtained it from the Court of Appeals website on June 11 of 2024.
Do you think it's possible maybe it's showing the lower court register of actions rather than the one for the Court of Appeals?
No.
Okay. So you said your first contact with me came in 2022 when you sent a cease and desist letter on behalf of your client, right?
Correct.
And I responded to that email asking you, how do you think I am harassing or trespassing on your client's property? Because wouldn't I have to first be doing something to cease and desist it, correct?
I don't recall every word of that email. Do you have a copy of it?
Yes, I do.
Okay.
Would you like to adjourn for...
No.
No. Okay. And isn't it true you didn't respond with anything to my request for you to describe how you think I've even been doing that to cease and desist it?
Objection relevance, Your Honor.
Okay, response on the objection to relevance, Mr. Cooper-Keel.
Well, what she said about her email contact with me in 2022 is completely false in her own direct testimony. She said I sent threatening emails then. Now she doesn't remember what even was sent.
Your Honor, may I respond?
You may.
Well, while it's accurate that I did ask a question about, I guess, the foundation for the PPO, or at least my intent to lay a foundation for the PPO, and we're not here to relitigate whether the PPO was properly issued, and we're not here to relitigate the case against that Mr. Cooper-Keel had filed against Ms. Fazio's client in that lawsuit. So that's why I object on relevance.
Okay. Well, the question of relevance is with regard to are the prior emails and the content of those emails relevant? I think their existence is relevant because, after all, these violations would have come via an email notice of this register of actions. However, the content and the reasons they were utilized as the basis for the PPO are not relevant to today's hearing. I'll sustain the objection and ask that you move on to your next question, Mr. Cooper-Keel.
Okay. Then in 2023, in your direct testimony just now, you claimed I said to you I was coming to your office. Is that correct?
Something to that effect, yeah.
Do you have any copy of any email saying something to that effect?
The emails that are the basis for the PPO that were received in January of 2023 from you were attached to the PPO application. I don't have it in front of me, but if you want to show it to me, I'm happy to talk about it.
So, isn't there no email that's been submitted with your PPO application where I said anything about coming to your office?
I don't think that's true.
Your Honor, I'd ask you to. Do you think it'd be fair? I guess I shouldn't ask the judge. Do you think it'd be fair for the judge to take judicial notice of what you filed and that it doesn't contain anything about coming to your office?
You'd better get comfortable hearing it, because throughout this entire video, you're going to see the judge constantly sustaining objections made by the real attorney.